Sir. Yes, sir. We are starting.
Greetings to the Honorable Speaker, Justice GS Sistani, former Justice Delhi High Court, Mr. Sunil Miglani ji, Chairman, Sir, Chairman, Chief Operating Officer, Ms. Tanvi Miglani, HLM Group, Dr. Anuj Agarwal, Sir, Mr. Dheeraj Sharma, Sir, Assistant Director, HLM Group, Principal, Head of the Department, and all the faculties of HLM College, and our utmost sincere students. A very warm welcome to our online session on alternative dispute resolution. I am your host, Aprant Agarwal, and I'm thrilled to have you here today. Whether you are a law student seeking to enhance your skills or a qualified faculty looking to deepen your knowledge in the ADR process, you have come to the right meeting. In a world where disputes and conflicts are an inevitable part of life, finding effective and efficient ways to resolve them is crucial. That is where alternative dispute resolution or ADR comes into play. ADR offers a fresh perspective on resolving conflicts outside of the traditional courtroom setting. Before we get into the final details of the session, I would like to mention some essential details of HLM Group of Institutions. HLM Group of Institutions was founded in 2005 by Mr. Sunil Miglani ji, CMD Mixon, in memory of his loving father, Shri Harbans Lal Miglani ji. HLM Group has its origins in the traditional education system, which aims to produce informed and talented professionals capable of adapting to changing economic and technical requirements. Our commitment to academic excellence, combined with a strong emphasis on practical experience, equips our graduates with a competitive edge in the job market. Over the course of 19 years, the group has expanded by leaps and bounds to offer 17 courses across 5 colleges with an alumni base of 35,000 graduates. The management at HLM Group The management at HLM Group consists of Mr. Sunil Miglani ji, Chairman HLM Group, Mixon, Mrs. Tanvi Miglani ji, Chief Operating Officer and alumni of Rice University, Houston, Texas, United States, Director Professor Dr. Anuj Agarwal, who has completed his MA, MBA, and PhD, and Assistant Director Sir Mr. Dheeraj Kumar Sharma, who has completed his Masters and MPhil and has served at the institution for more than 18 years. Having gone through a brief introduction, it is time to embark on this exciting journey of discovery and growth. Our online session on arbitration and mediation is here to open doors, broaden horizons, and transform the way you approach conflicts. Let us embark on this transformative adventure together. I would now request Director Sir Dr. Anuj Agarwal to introduce our honorable speaker so that we can dive into the principles that underpin the approach to arbitration and mediation. Over to you, sir.
Thanks, Aprant. A very good morning to all of you. This is Dr. Anuj Agarwal, Director HLM Group of Institutions. Ladies and gentlemen, distinguished and valued participants, I welcome you all on this very informative organized by HLM College. It is my great pleasure to introduce to you to our esteemed speaker for today's session Honorable Mr. Justice GS Sistani, sir, who has very kindly consented to be a part of this session. Our speaker is true legal luminary with a wealth of knowledge and experience. He has dedicated his life to upholding law, disseminating justice, pushing bounds, challenging norms, and inspiring others to dream big. Honorable Justice Sistani, impactful contributions have significantly influenced the legal landscape of Delhi High Court and the Supreme Court of India. His academic journey began with graduation from the prestigious Hindu College of Delhi University. He has achieved his LLB degree in 1982. Embarking on his legal odyssey, Honorable Justice Sistani enrolled as an advocate with the Bar Council of Delhi in 1982. His professional started at Core and Company Advocates. Later, he joined his esteemed father, Shri SNS Sistani ji, a very reputed senior advocate. His commitment extended to his roles as an advocate for the Delhi government and the Delhi Development Authority, as well as serving as an amicus curiae in numerous High Court cases. The apex of his judicial career occurred with his appointment as an additional judge of the Delhi High Court in 2006, concluding with a well-deserved retirement in 2020. As the sixth chairperson of the Delhi High Court Mediation and Conciliation Center, he enhanced the cause of mediation, orchestrating activities to raise awareness during Samadhan's 11th year. With an impressive background in legal field, Justice Sistani has not only excelled in his professional endeavors, but also has demonstrated a deep commitment to sharing his wisdom and expertise with others. His passion for arbitration and mediation is contagious, and his ability to connect with the audience is unparalleled. Today, we are very proud of that he has joined us. Our renowned speaker will be sharing his valuable insights, offering practical advice, and providing inspiration that will leave all of us motivated and ready to take on new challenges. So without further ado, let us give a warm virtual welcome to Honorable Justice GS Sistani, sir. Now, over to you, sir.
A very good morning, Mr. Meglani, the chairman of HLM Group, and Mr. Meglani, who has graduated and is an alumni of the Houston University, professors, teachers, and the students. I thank the management, particularly Dr. Anuj Agarwal, for giving me this opportunity to be with you all this morning. Alternate disputes redressal, ADR as we normally refer to, is a very vast topic. The Code of Civil Procedure was amended to introduce Section 89. With the introduction of Section 89, the ADR system was given its foundation. When we talk about ADR, under the umbrella of ADR, there is arbitration, there is mediation. Both these forums will be touched upon this morning. Additionally, there is conciliation, there are lok adalats. The main objective of introduction of Section 89 was that the docket busting, the large number of cases, could be decided by an alternate resolution method. But let me tell you one thing, that in my view, an alternate dispute redressal mechanism, in fact, mediation is here to stay. And mediation over the years has and will continue to perform a very important role. But before that, Let us talk about arbitration. Initially, the Arbitration Act was of 1940. This act was a subject matter of a lot of criticism over the years. Appointment of an arbitrator could take years. During that time, a Section 20 petition was filed. Thereafter, even after the arbitrator was appointed, the arbitrator could give an unreasoned award. That is, he could give his judgment, an award. A judgment by an arbitrator is called an award. He could give no reasons if he wanted. And thereafter, it was like another trial. You would file objections. You have to serve the other side. Objections were heard like a regular appeal, and the matter would go on for years. Even after the objections were dismissed, there was a procedure of filing an application by the successful party for making the award rule of the court. So that was another layer which caused a lot of delay. So in 1996, the Arbitration Act was amended. Most of these issues were taken care of. Appointment of an arbitrator became more of a mechanical act. And accordingly, the layer of making award rule of the court was taken away. The moment an award was rendered, it was like a decree of the court. Time-consuming factor was also taken into consideration. Under the new act, the pleadings are to be completed within 6 months, and the award is to be rendered within 1 year, with parties having the ability to extend it for another period of 6 months and no more, after which extension can only be granted by the court. So on paper, whatever were the deficiencies of the 1940 Act were made up. So if your question is that, has everything become in order? Has the delay been taken care of? My answer would be in the negative. Something which I continuously use is the byproduct in any factory depends on the raw material. So if the raw material does not change, then the byproduct will also not change. Now, let me give you another example. You know, in the good old days, if you ever went to some local markets, for example, the paper market in Chowdi Bazaar or the motor market in Daryaganj, etc., they always had an inbuilt arbitration clause. And that clause said that in case of dispute, the president of the motor market will be. Same sort of clauses were there even in the paper merchants market. Now at that stage, the president of the motor market or the paper market or any such market was always considered to be a man of high integrity and repute. So if a dispute went to him uninfluenced by any political or any other motives, he would decide the matter, call the parties and say, look, he has supplied you the goods, you have not made the payment, you have not been able to show that there was anything wrong in the goods. Now I am giving this award, you make the payment, you want time, I will grant you time. Now, how was this award implemented? it was implemented both legally and socially. Legally, it had the binding effect, and socially, it was also made clear that nobody will deal with this man now because he's a dishonest person. So for years and years, this system worked beautifully. Why it worked? Because the arbitrator, the named arbitrator, whether he was the president of the market or whoever was the named arbitrator, everybody had faith and trust in him. And they knew that his integrity was unmatchable. System was clear, it was quick, it was inexpensive. Today we talk about institutional arbitrations. Institutional arbitrations are when there is a named arbitrator, named forum, PhD Chamber of Commerce, ICDR, so many other forums are named forums. By the judgments of the Supreme Court, now you can't name an arbitrator unilaterally, which means that earlier the party who was the dominating party, for example, in hire purchase cases, banking cases, other such cases, they would say the managing director of the company will be the arbitrator. In government contracts, they would say chief engineer would be the arbitrator. So struck down. They say either the arbitrator will be a person who is agreed upon by both the parties, or each party will choose one arbitrator and both the arbitrators will then appoint the presiding arbitrator. See, practically, you've heard I joined the bar in 1982 and I practiced till 2006. From 2006 to 2020, I was a judge of the High Court. And from 2020 till now, I have been an arbitrator. So what I'm sharing with you is a flavor of the three roles which I have played. And I can tell you that arbitration is not as simple as it is made out to be. Some of the issues are extremely technical. They deal with power plants, energy, windmills, you name it, and there can be a subject matter, and it sometimes runs into hundreds of crores. It is complex. Sometimes there are a panel of three. There are experts also in the panel, but it is time consuming. But the roadblock is not really before the arbitrators now, for the reason that a time period has been fixed. So after 18 months, when you go back to court to seek extension, courts are normally very careful. They would like to know what is the reason for delay, why is it taking so long? And time is extended, and rightly so. But it is not as if it is unending, which used to be in the earlier days. Very unfortunately, some of you would be aware and would have read that the government has now taken out a circular by which they are saying that only disputes of less than 10 crores should be referred to arbitrations. Apparently, they are unhappy with few decisions which have come about in the recent times. In my view, that's not really the answer. Arbitration is a forum which is internationally acclaimed. Whether it's the Singapore Institute or the London Institute or wherever. So the answer will not really lie in saying that we are unhappy with the awards. Ultimately, there will have to be some soul searching at their end as well to find out why. So if you give contracts, whether they are road making contracts or there are construction contracts, something which comes about in most cases are the delays. So every contractor says, I was not given the plans on time. Every government body says he did not have the manpower, the machinery, the resources. Contractors say we were not given the mobilization advance. Our bills were not clear on time. So like I said, that what is the real requirement is that somebody should sit and process the awards and see that where is the lapse, and then take a call, and not the knee-jerk treatment which we always do in all matters. If there were financial frauds, we introduced the debt recovery tribunals and we made the appellate tribunals. We had the Nirbhaya case, we said we amend the IPC. These are not real answers. There's nothing wrong with laws in India. Where we lack is some element of implementation. Yes, once the awards are rendered, a section 34 is filed, 33, 34, and objections are directly by the judge. There lies under section 7, and thereafter there is always an SLP. Having given you a bird's eye view of the Arbitration Act, let me come down and share with you what is in store as far as mediation is concerned. Mediation, at least in Delhi, is been very, very recent. When I say recent, it was introduced in 2005. And as expected, there was a lot of opposition by the lawyers. They thought that mediation would take away their work. Everything would be decided by a mediator. So there was contemplation that they would oppose it. At that time, Justice Karju was the Chief Justice and Mr. Chandeok was the President of the Bar. So he took him into confidence, and what emerged was a mediation center to be run by the lawyers, to be overseen by the judges. It's a very unique system, and I will tell you that it's a very, very successful system. The High Court Mediation Center started in one room. Mediators, and over the years, we have more than 2 floors. We have more than 500 to 600 trained mediators, including myself. I got myself trained as a mediator when I was a judge. Then I did advanced training from Pepperdine University in the US. And I was part of the mediation committee. And then till my retirement, I remained the chairman of the mediation committee. So as far as I am concerned, I have been advocating mediation. Even as a sitting judge, after the hearing, after court hours, I would mediate, and successfully. Today, there is a long list every day which is published, like the High Court cause list which used to be published. And we have an extremely high success rate. So the question is, what is mediation? Why mediation? Now, see, a litigant, barring a corporate, etc., a common man litigant has huge issues. For example, if he is to file a petition, it will take him a long time to mentally decide to file a suit, because it will be against the brothers, sister, uncle, auntie, etc. So there is always this quandary whether I should file, should not file. Finally, he does go to a lawyer, and most lawyers are extremely busy. So the general idea is you just tell us something, yeah, I know everything, I know everything. So he never gets an opportunity to really pour his heart out. Courts are very highly burdened, and a party never gets an opportunity to address the court. A standard answer by all judges is, please speak through your lawyer, because you have engaged a lawyer. Don't address the court directly. Something which I also used to say, later on I realized that sometimes the client, because it gives you a much better idea, and in a show you can understand where the shoe is really pinching. So why mediation? What are the advantages of mediation? See, mediation is firstly inexpensive. The High Court Mediation Center is free. Now there is a concept of pre-litigation mediation, which I will touch upon, because even the Commercial Court Act has been amended, Section 12A. I will just come to that. So the first advantage of mediation is that it is inexpensive. The second advantage is that there is finality. Now, when I say finality, there are cases where people have come from one court to another, and yet there are 2-3 forums of appeal. So if there is a settlement by mutual consent, so there will be no appeals and there will be finality. As an example, you see in certain family matters, 498 is filed by the girl dowry act. So in retaliation, the boy's side will file some FIR in some other court for harassment. Then a suit for partition is filed. Simultaneously, a petition for custody is filed. In retaliation, he will file for divorce. Then she will file for maintenance. Now, what happens is there is a bouquet of multiple litigations. So if there is a settlement through mediation, sometimes as many as 8 or 10 cases get decided by one settlement. So here is an example that there is finality. Now, this is not restricted only to family matters. You look at commercial matters. We always say another advantage of mediation is it restores relationships. A successful partition suit can get back two brothers. I'll give you an example. In my court, there was a partition suit, and I found that both the brothers had 50% share, and yet they were litigating. So I could see these elderly gentlemen standing together, and I just said, "Ki bhai, dono ka 50% hissa hai, jagad kyun rahe ho?" So simultaneously they spoke, and the elder out of the two said, "He never asked me for partition. इसने कभी मांगी नहीं partition." उसने कहा, "भाई साहब, आपको पता तो है कि मेरे बच्चे की शादी हो रही है, घर में जगह नहीं है, कमरा आप बनाने नहीं देते हो, मैं कहाँ जाऊँ?" So I said, "All right, after lunch, you come to the chamber." So I called both these elderly gentlemen to the chamber, and I told the younger brother, "Bhai, you request your brother." So he very politely said, "कि जी इसको कर लो जी, फैसला आधा आधा तो है ही है." He said, "मैंने तो कभी मना नहीं किया, तुझे कौन सा हिस्सा चाहिए?" So, and believe me, the time which I am taking to explain, we were able to settle. And on that day, I passed a preliminary decree. I said, "Go back, take a draftsman, which post to whom, and I will pass a final decree." Now, this can only happen in mediation, because you get an opportunity not only to address the mediator, but unlike arbitration or court proceedings, you decide what order you want. You are the one who has to decide what is going to be my settlement. And obviously, if the settlement is by you, there will be satisfaction. If there is satisfaction, there is finality, relationships are restored. So both the elderly gentlemen that day went back in one car in the same house. They used to come in two separate vehicles and go back most unhappy. So it restores relationships. An example which is given in every mediation seminar is what I am going to narrate to you. A multinational was making jeans. A local person who was copying the jeans. Matter was sent to mediation. During mediation, the multinational's representative told the man, why are you copying our jeans when your material and your stitching is so good? Parties entered into a settlement, and the settlement was, amongst others, that this man would supply jeans to that national company, their label, instead of making duplicate jeans. This is a fantastic example of how relationships can be restored. We've had cases where in years, 10 years, things have gone bad. Very recently, as a mediator, High Court had referred a matter to me, and I found that these people were making crores of rupees, and they had a very simple business. So I called them, and they were not from Delhi. Since mediation is confidential, I cannot divulge more. And I found that there were three very good friends who had started this venture, and they were doing so well. So when I spoke to them individually, they felt that, look, everything is all right. Now, one of the managing partners, some of his family members who have now grown up, they have started interfering and questioning us. So we have seen these kids grow up. Today, they can't question us. So this was a case of ego being badly hurt. So I sat with them. It took me about 8 to 10 hearings to explain the downfall which I am a mediator. Doesn't stop, the court will receiver. If a receiver is appointed, your banks will get jittery. Your suppliers will get jittery. The downfall will begin. So after much persuasion, but something again which I keep repeating in all my mediation sessions is that mediator can't be a person in a hurry. A mediator has to be a very patient person. So I will come to that a little later. And we were able to resolve it. All cases don't get resolved. Let me tell you that also. See, there can't be resolution unless there is a pot of gold on both sides. So sometimes it suits a person to litigate. So whatever advantages you may tell him, he will keep hearing and he will keep nodding his head. In his heart, he says, "Maine to faisla karna nahi hai, mujhe to suit karta hai." So this restoring of relationships is again an important factor. So I have touched upon finality, touched upon informality of proceedings. They are inexpensive and it restores relationships. So these are basically all very win-win situations. But then, what is the catch to it? See, the catch is parties are apprehensive. So they go to court. Everybody knows that there is a lawyer. Everybody knows that there are courts, there are judges. But everybody doesn't know that there is something called a mediator. So when the courts refer the matter to the mediator and the party appears before you, he's not happy because he's apprehensive, there is insecurity, because he doesn't know who you are, what is your role, and nobody really explains it to him. So in the mediation training, it is extremely important for the mediator to explain to the parties who is he, what is his role, what is he going to do, what is the procedure he is going to follow. Till he does that, he cannot expect any party to open up and give his point of view. So a mediator is a neutral person. He has to explain to the parties that I have been appointed by the court and I have no relationship with either of the parties. Then he must explain that I cannot force you to enter into a settlement, because a party does not want this burden as if he will put me in the room and make me sign something. So the mediator must explain, which he does, that look, I am going to hear you, I am going to guide you. But ultimately, it is you and the other side who will think of a solution. Sometimes bills are stopped. Some items are not as per specifications. So mediator says, all right, जो goods ठीक है, आप इसके पैसे दे दो. जो खराब है, इसके बारे में सोच लेते हैं. So when the guard comes down, then parties come up with solutions. They'll say, अच्छा ठीक है, जो तुम्हें लगता है कि specification नहीं है, इसके तुम 50% दे दो. या चलो मैं interest कम कर देता हूँ. And then things start falling in place. See, in court, what happens in commercial disputes is the owners are not there. So if A manager of one company has a tiff with B manager of the other company, he'll say, court में देख लेंगे. Court में तो देख लोगे, but किसका advantage है? You pay court fee, you spend court time, there is delay. If you have to take 20 lakhs or 20 crores, see the element of interest. Even the amount which you have to pay, the court is bound to say, look, this is an undisputed amount. You have held on to undisputed amount for 5 years. Now you pay interest. We can understand you withheld amounts with disputed issues. Similarly, you look at bank disputes. There are borrowers. Now, borrowers don't realize that the bank meter will never stop. Bank cannot give concession unless you are declared an NPA, etc., and all that. And if the bank has an immovable property mortgaged, they will never settle. They settle only in those cases where they know they will get nothing. When the property is mortgaged, they know the property is there, we will sell it, get the money. So, getting back to mediation, these are the advantages. But is the decision taken before the mediator binding? That would be the logical question. The answer is yes. When parties sign on a mediation settlement, it goes to court and the court ratifies the same. So there is a full circle. So it is not as if mediation is all fun and play and parties can spend time. Now, when you refer the matter to mediation, this is again something which is very often said by me. Don't do it mindlessly. Because every matter is not a matter which can be sorted by a mediator. So by sending a matter which cannot be sorted by a mediator, the matter is being delayed by the court. So the court must actively first consider whether this matter can be settled by a mediator. And the court must also actively hear the counsels and only then send the matter to the mediator. And the mediator should also keep the rope very tight. Suppose a party says, the main person is not coming, then he's not interested. So at least my standard order used to be list before the mediator when a person who is in a position to take a decision in the matter shall remain present. And if he does not, the mediator was told, you send the matter back, so that the person does not take advantage and delay the matter. So every system is to be manned. You can have the best of facilities. You can have the best of infrastructure. But unless and until somebody is there to man them, you will never get the desired result. So I have given you a bird's eye view in more than 40 minutes of why mediation, what is mediation, what are the advantages of mediation. I have also touched upon, because arbitration is a very, very vast, and according to me, it should have been the simplest act, but it is the most complicated act. As you go by and by in the arbitration proceedings, you can have an agreement which says the seat of arbitration will be London, laws of India would apply, and jurisdiction will be of Singapore courts. So if a Section 9 for interim relief comes, you will keep deciding which court to go to. And if the order is passed, which court will it be challenged? You have decisions of Bhatia, etc. Kusum Ingot, so many decisions are there, but there are so many question marks as well. So I'll be too happy to take any questions, any clarifications from everyone and anyone who wishes to do so. And I also wish to add that it's surely very impressive that HLM is doing so well with 5 colleges giving 17 courses. And above all, the respect goes up when a person dedicates something to his own father. So I'm sure Senior Mr. Miglani, Banslalji Miglani, would be a very happy soul that his family is doing so much, and parting education is considered to be very, very high in matters of ethics, because you are educating people. And you are the ones who are giving future citizens to this country. And I hope they will all add to all what is happening. Yes, questions?
Thank you so much, sir, for the wonderful session. A few questions, and one faculty have some questions. So first would be from Khushi Chaudhary. Khushi, can you please unmute yourself?
Good morning, sir. Sir, my name is Khushi. I'm from BLB 4th year. Recently, I gave my exam of arbitration. So I have one question to ask you. Sir, do I give up any right if we go for arbitration?
See, arbitration is in itself a forum of decision. So, in fact, if parties decide on arbitration, then an arbitrator is appointed. Either both of them agree. Suppose a dispute arises, so A will write to B, there is a dispute. We have already decided on Mr. X as arbitrator. Please come and join the proceedings. If he doesn't, you go to court and say there is an arbitration clause. The court will appoint an arbitrator. So you're not giving up any right. It's a different forum, that's all. And a judicial forum.
Okay, sir. Thank you.
Thank you for your question, Khushi. So we have Meenakshi Athar next, who has a question. Meenakshi, can you please ask a question?
Yes. Good morning, sir.
Good morning.
Sir, my question is how far the role of arbitrator can be compared to that of judges in the court system?
See, the role is exactly the same. Judge has to be impartial, arbitrator has to be impartial.
Yes, sir.
Arbitrator gives a declaration under section 12 that I don't know the parties, I have no concern with them. Judge must apply the law, arbitrator must apply the law.
Sir, but under section 12, ground of challenge of arbitrator, something like that.
See, they can always, what are the grounds of challenge? The grounds of challenge are that he did not apply the law.
Yes, sir.
He ignored some, suppose the agreement says something and the arbitrator overlooks the terms of the agreement.
Yes, sir.
So practically, how would you file an appeal against the order of a single judge? Same thing. Except they say that the scope of interference in arbitration is very narrow.
Okay.
Right? These are what all the judgments say. That
Yes,
the award is not to be decided like an appeal. You have to only look that there's an error apparent on the record. But practically, judges do look at everything. It's not that they don't.
Okay.
If two views are possible and the arbitrator has taken one view, please follow that view. But if he's taken a completely wrong view in law, then there is subject of challenge. But role, there is not, I don't see any difference.
Thank you so much, Meenakshi. Next in line, we have Harshit. Harshit, please unmute yourself.
Okay. Hello. Good morning. Good morning, sir.
Good morning.
So my question is, what ethical rule do you follow as an arbitrator?
I'm sorry?
So what rules do you follow as an arbitrator?
No, your voice is cracking.
Hello.
Yes.
So what rules do you follow as an arbitrator?
No, what rules?
Yes, sir.
Rules. See, like the earlier question asked by Meenakshi, there is no difference. Can you hear me? See,
hello.
There are no difference.
Yes, sir.
Except that the Act says that strict rules of evidence would not apply, strict rules of CPC would not apply, but it also says that you have to be guided by them. So pretty much things are the same. So it's not that the arbitrator can go completely berserk and, you know, he will not go by what is the rules of evidence, or, you know, he will not give an opportunity of hearing. So here also, in the courts, you file a plaint. Here you file statement of claim. There you file written statement. Here you file statement of defense. Their issues are framed. Here you say points for determination. Their evidence is led in court. Before arbitrator also evidence is led. Court can also say it's a matter of documents, no evidence. Arbitrator can also say parties agree, no evidence, decide on documents. Court hears final arguments, arbitrator hears final arguments. Court gives judgment, arbitrator gives an award. Judgment of the court, you can file an appeal. Award, you can file objections. One appeal goes to the single judge, then division bench, then Supreme Court. Here single judge, division bench, Supreme Court. So it's pretty much parallel. But it's supposed to be quicker, right? Because of quantum. As a judge, I would get 60, 70 cases a day. As an arbitrator, I do 1 or 2 arbitrations a day. So that's the difference.
Thank you so much for your question, Harshit. And we'll take few more questions. We have next question from Bela Bansal, and then we have a question from our faculty. So Bela, can you please ask a question?
Good morning.
So people still are not believing in arbitration. They are still going to litigation. So how we can change their perception?
See, a lot of people talk and say that Indian courts are very slow. You will find a lot of statistics which is thrown at the public कि इतने लाख केसेस पेंडिंग हैं. जो मैं आपको बता दूं उसमें बहुत से लाख चलान के केस होते हैं और वो भी ऐड किए जाते हैं. और फिर हमारा ये 138 आया, नेगोशिएबल इंस्ट्रूमेंट्स एक्ट. तो पीपल आर वेरी क्लेवर. सो अब आप देखिए 1 लाख के ऊपर कोर्ट फी कितनी लगती है और नेगोशिएबल इंस्ट्रूमेंट्स एक्ट में तो कोर्ट फी लगती नहीं है. तो अब जैसे हायर परचेज है, आपने 3 साल के लिए हायर परचेज करा और आपने 36 चेक ले लिए और वो बाउंस होते गए और आप हर 3 बाउंस के लिए एक कंप्लेंट फाइल करते हो. तो हायर परचेज कंपनी और बैंक्स ने तो फ्लड कर दिया नेगोशिएबल इंस्ट्रूमेंट्स एक्ट के केसेस, 138 के केसेस. सो देयर वाज अ बूम देयर आल्सो. आवर सिस्टम इज, देयर इज नो डाउट अबाउट इट. It's like any government hospital. You go to an OPD of hospital, you see 300 persons standing in there. Can take care of 300 people in 2 hours. So that problem is there. We must. आप कोर्ट में टाइम मत दीजिए एक पार्टी को या वकील को बोलिए एडजर्नमेंट के लिए टाइम मत दो. आप कहते हैं जी कोर्ट में एडजर्नमेंट होती है. I'll tell you क्यों होती है. See, if you have 50 cases and if 10 people are not ready, you will say ultimately, please go away. You are not ready. Don't waste my time. At least जो 40 तैयार है उनको तो सुनो. But हाँ, something which I would follow is that if a person is taken adjournment once or twice, then he will not get adjournment the next time. So you pull up. So similarly, in arbitrations, now see, the government is feeling insecure. People, there were times when arbitrators were appointed who were retired bureaucrats, retired from MCD, engineers, etc. And there are some black sheep in every system. I can't say that 100% people from judiciary or 100% people from MCD or NDMC or railways or wherever. So people do sometimes get disheartened. But then the corrections are done. That is why there are appeals.
Lot of.
So if appeals are there, the purpose of appeal is if somebody is faulted for whatever reason, for good reason, say lack of knowledge or integrity issue, then the next court will undo it. So arbitrations are there. It's not as a people, but it can't match the court system. That's an institution. But a lot of people do refer to arbitrations. And a lot of contracts, the bigger contracts, have an arbitration clause.
Thank you, sir. Thank you.
Thank you so much for your question. Sir, do you have the bandwidth to entertain 2 more questions? Because one we have from a student named Reena and one from a faculty, Ms. Stuti Rastogi.
I have no problem.
Sure, sir. So next in line we have is faculty, Ms. Stuti Rastogi. Ma'am, can you please unmute yourself?
Good morning, sir.
Good morning, Mr. Stogi.
Thank you for such an informative session, first of all, sir.
Thank you.
Sir, my question is regarding the future prospects. Like with the technological advancement right now, what can we expect arbitration? Can we expect arbitration to get online in near future? And how?
See, arbitration has been online throughout COVID and even now.
Yes.
So most of the procedural issues are done online, and we go for physical hearing during recording of evidence and arguments. Some arbitrators are doing everything online. Supreme Court judges retired, they are mostly doing online arbitrations. It saves time. But sometimes personally I feel जैसे वो नब्ज देखनी होती है ना वैद्य को या डॉक्टर को, तो कई आर्बिट्रेशंस में वो नब्ज वाली बात भी होती है. तो this is my view. Everybody doesn't subscribe to this. Everybody feels that everything can be done. We are doing this session virtually. We've saved so much of time and everything. 1 hour here otherwise would have meant couple of hours of travel up and down. So most arbitrators are doing virtual hearing. Even courts are doing virtual hearing.
Thank you, sir.
Thank you so much for your question, Suti ma'am. Sir, I'll take 2 more questions from the chat box. So first is from Akhil Ahmed. What is the future of arbitration after the recent MOF circular?
See, I mean, it's not a very heartening circular considering it's diametrically opposite to the stand taken where all over all forums we have been advocating that make India the arbitration hub, etc. So you can't make your country the hub when you yourself don't have faith in the system. So anyway, nothing is going to happen overnight. We have to wait and watch. And let's see. Like I said, sometimes there are knee-jerk reactions. A better thing would be that somebody should take on a study and say that why there are awards against the government. What are the reasons? So one has to put your own house in order. No? It's like saying कि सारे बैंक के केस तो बैंक की फेवर में जाते हैं. Actually, अगर आप लोन लोगे, डॉक्यूमेंट साइन करोगे, पैसे लोगे और नहीं दोगे तो आपकी फेवर में थोड़ी ना जाएगा. So similarly, अगर आप कॉन्ट्रैक्टर को ड्राइंग नहीं दोगे या if there is a lapse, it can be either ways. It's not, I mean, I have given awards against the contractors also. I have also held in so many cases that, you know, the lapse is not on the part of the government. So it's both ways.
Thank you so much, sir. So we'll just take one more question from Mr. Ariman Raghuvanshi. His question is, so he finds the section 34 of ADR very challenging. And the next question he has is that his father is serving as a personnel in paramilitary and that he is hearing that the cases are being transferred to the High Court directly. Can he do something to spread any sort of awareness in the department so that there could be quick and crisp resolutions to the matters?
See, I don't think paramilitary matters will go to the High Court. I'm not sure whether they are covered under the Armed Forces Tribunal, whether it's paramilitary is covered or not, I can't say. You can go through the Act and see whether paramilitary are covered. If it goes to the High Court, there is no harm. There's always been one bench which hears armed forces cases which are not covered under the Act. And in fact, after my elevation, first 6 months I sat in the division bench. Forces cases, promotions, court martials, their pension, disability pensions. So there is no harm. I don't see one forum better or worse than the other. As long as justice delivery system is there and justice is being delivered, nobody should have a problem with which forum. But then certainly this is to be micromanaged by the legal, whoever is advising.
Right, so thank you so much, sir. So it was indeed one of the best sessions we have had on the topic of ADR. I would like to now request Director Sir to take over the mic and give a vote of thanks. Over to you, sir, please.
First of all, I extend my heartiest thanks to Hon'ble Justice GS Sistani, sir, who
Thank
have
you.
spared his most precious time with us. Sir, it is a matter our faculties and members and students will definitely get benefit from it. And sir, the wisdom you shared will be eye-opening for them and for us also. And sir, I am looking forward to have interaction with you in future also at our college campus. So sir, thank you once again for sparing time. Thank you, sir.
Thank you.
Yes.